Florida's Stand Your Ground law did not save Susan Lorincz. And the reason comes down to one locked door. On June 2nd of 2023, Ajike, or AJ Owen, a mother of four, went to her neighbor's front door after another conflict involving her children. Susan Lorincz was inside. AJ Owens was outside. The door was closed, and Lorincz fired through it. If you watched Netflix The Perfect Neighbor, you saw the neighborhood conflict unfold through police footage. But today, we're looking at the legal question underneath the tragedy. Why did it take days to charge Lorincz? Why was she charged with manslaughter instead of murder? And why did Florida's Stand Your Ground law fail in this case? This is not just a story about a neighbor dispute. It's a case study in the difference between fear, anger, and legally justified deadly force. I'm Chris, and this is Eagle Eye Cry. This is a first video in a new series where we're going to look at Florida cases connected to the month they happened. Not just what happened, but what these cases teach us about the criminal justice system. This case teaches one important lesson. Florida law may allow you to stand your ground, but it does not allow you to shoot through a locked door simply because you claim you were afraid. Before we talk about statutes, charges, and legal defenses, we need to start with the person at the center of this case. Ajike, or AJ Owens, was not a legal hypothetical. She was a daughter, a neighbor, a woman raising four children. And on June 2nd, 2023, her children lost her in a way that no child should have to witness. This case is disturbing, not just because of the shot itself, but because of everything that came before it. According to reporting from the Associated Press, Lorincz and Owens have been involved in an ongoing dispute centered around Owens' children playing near the homes. Netflix's documentary, The Perfect Neighbor, focuses heavily on that buildup. They use police footage and neighborhood interactions to show how repeated calls and conflict created a tense environment. And I'm going to be very clear about something. I'm not here to recreate Netflix's documentary. If you want that deeper visual record, the body cam footage, the emotional buildup, and the neighborhood interactions, that documentary is definitely worth watching. But this episode is going to do something different. We're going to look at the law, because this case raises questions people were asking almost immediately. Why was Susan Lorincz not arrested right away? Why did prosecutors choose manslaughter? Could this have been murder? And what does Florida's Stand Your Ground law actually protect? Here's a quick recap of the case. On June 2nd, 2023, in Ocala, Florida, Susan Lorincz shot Ajike, or AJ Owens, through Lorinc's front door. The Marion County Sheriff's Office investigated and arrested Lorincz. AJ Owens was outside. Lorincz was inside, and the shot went through the door. And the legal question became, did Lorincz reasonably believe deadly force was necessary at that exact moment? Not 5 minutes earlier, not based on every prior conflict in the neighborhood, but at that exact moment. That's the difference between a tragedy and a legally justified shooting. And in this case, the jury did not find the shooting justified. One of the biggest questions in this case was, why did it take days to arrest and charge Susan Lorincz? That delay angered a lot of people, and honestly, that reaction makes sense. When someone is shot and killed, the shooter is known, and the victim's family is grieving. Every hour without an arrest can feel like the system is standing still. But legally, these cases can become complicated very quickly. Florida statute 776.032 says a law enforcement agency may investigate a use of force, but it may not arrest the person unless it determines there's probable cause that the force was used unlawfully. That matters because when someone claims self-defense, investigators cannot simply say, well, someone died, we've got to arrest the shooter immediately. They have to evaluate whether the shooting might be legally justified. Now, before anyone throws a chair through the comment section, this does not mean the delay felt fair to the family or the community. It does not mean the delay was emotionally acceptable. It means investigators and prosecutors had to build a case that could survive that self-defense claim, and that distinction matters. This is one of those moments where the justice system and public grief operate on completely different clocks. The public wants action. The law demands proof. And sometimes that delay creates distrust, especially in cases already surrounded by racial tension, neighborhood conflict, and a victim's family asking why the person who fired the shot was not immediately in custody. To help break down the legal side of this case, I asked law professor and former Florida prosecutor Chastity Branham to explain Florida law as it relates to this case. In Florida, when someone claims self-defense after a deadly shooting, what does law enforcement have to determine before making an arrest?
So in Florida, back in 2005, when we went to stand your ground and there were some law changes and have continued to be over the last several years, it kind of changed the way that law enforcement has to investigate in a situation where they show up on a scene where a tragedy has occurred, there's a fatality, and they're being told, I felt like I was in fear and I operated in self-defense. And so law enforcement, based on the Florida statutes that we'll be talking about, they no longer can just automatically make an arrest because there's a fatality and there's an obvious potential crime that's occurred. Instead, they've got to use the standard investigative techniques and procedures, but they can't make an arrest until they are able to establish probable cause that the force was unlawful. Not just that the force occurred, but that it was unlawful in accordance with Florida statutes, Chapter 776. So they've got to gather evidence to determine whether or not it was justified before they can make an arrest. They've got to be conducting their preliminary interviews. They've got to try to speak to the person claiming the self-defense to find out the circumstances from their perspective, at least what they're alleging gave them reason to fear. They're documenting the scene. A huge key would be getting all of surveillance that would be available, ring cameras, neighbors, any cell phone, all of those things to take a big picture look at the totality of circumstances to establish probable cause that it was unlawful use of force, no longer just use of force.
When the public sees a delay in charging someone and they automatically jump to that conclusion that nothing is happening, what may actually be happening behind the scenes?
There's a lot of things that are happening. It's understandable for the general public that does not have kind of a curtain view into what's happening to get frustrated, to equate that to mean that law enforcement's not doing anything or the state attorney's office is refusing to go forward, and that's simply not the case. By Florida statute 776.013, 776.012, and 776.032, there is potential immunity in situations of self-defense if it stands your ground. And so what law enforcement, in combination with the state attorney's office of that particular county or venue of that judicial circuit, What is happening is that they are trying to ascertain whether legally they could go forward with the charge. And so law enforcement, of course, is extremely busy in doing supplemental investigations, attempting to not just deal with what they found at the scene, but what's the history there? Are there history between the two, the potential defendant and the victim in this case? Did they have a lawful reason to be there? There's a lot to unpack in the history that may play into whether or not this use of force was justified or not. So the evidence collection, the investigation is still happening, but that is also when the state attorney's office is particularly involved going through the statutory requirement. Was there evidence of a reasonable fear of imminent danger? Was the person that used the force, were they the aggressor? So they're no longer immune or no longer have the immunity of the statute. So there's a lot of behind the scenes, because in Florida in particular, like in other states, the clock starts ticking, so to speak, when an arrest is made. What that means is speedy trial, as we have here. There are certain days that are labeled that a defendant has to be brought to trial within, and it varies from misdemeanor to felony charges. Obviously, we're talking about felony charges. I think it's around 176 days. So always law enforcement needs to be very diligent to not make an arrest or start that clock from ticking too quickly, because the state attorney's office may not be able to gather all their evidence before being required to go to trial. In this particular type of a case, in a stand your ground or self-defense type case, because of the way the statutes are written, a hearing is going to take place prior to trial happening if a defense counsel wants to assert a stand your ground defense. And if the defense counsel files a motion to dismiss, is what it is, to argue in front of a judge a preliminary or a pretrial immunity that says, my person can't be prosecuted for this. What they did is covered under the Florida statutes, and so what they did was justified. They are barred from prosecution. So all of that is what's going on behind the scenes during that waiting process, that the general public could easily think nothing's happening. But in actuality, there's lots happening to ensure that if the state charges, if they allow law enforcement to make the arrest, that they have the evidence needed to go forward to try to prove a case beyond a reasonable doubt, which is, of course, the highest legal burden there is.
Now, let's talk about Florida's stand your ground, because this phrase gets thrown around constantly, and most of the time people use it like it's a magic spell. It's not. Florida's self-defense law is found in Chapter 776 of the Florida Statutes. Florida Statute 776.012 says a person may use deadly force if they reasonably believe that using deadly force is necessary to prevent imminent death, great bodily harm, or the imminent commission of a forcible felony. Reasonably, necessary, imminent. Those three words matter. Not, I was annoyed. Not, I was angry. Not, we had argued before. Not, I felt disrespected. Not, those kids had been getting on my nerves for months. Deadly force requires more than fear. It requires reasonable fear of an imminent threat. The stand your ground part means that if a person is in a place where they have a legal right to be and they are not engaged in criminal activity, they generally do not have a duty to retreat before using lawful defensive force. But that doesn't answer the biggest question. The biggest question is still, was deadly force lawful in the first place? Because stand your ground does not make unlawful force lawful. If the door is closed and the person is outside, the question is whether the person was actually unlawfully and forcefully entering.
So can you explain the difference? You mentioned self-defense, and then you're
Yes.
also mentioning stand your ground. Can you explain the difference between the two?
Absolutely. So in Florida, and I know I'm kind of throwing out some numbers, but I think it's important if people are listening that they might want to take a look at how tediously written the statutes are and how specific they are. And this really is what drives law enforcement and the state attorney's office in these type of cases. They have to be statutorily accurate, and they have to make sure what seems like a small detail that it is met. So in 776.013, it's commonly called the castle doctrine. So it's I'm at my house. If somebody's breaking in, that law gives me a statutory presumption that I am in reasonable fear of imminent danger or death, serious bodily injury. So I have the legal right to protect myself in those type of situations. A stand your ground defense is a variation of that. It's an expansion of it, I guess I would say. And that is found specifically in 776.012. And what this is essentially in layperson's terms is saying is if I have a legal reason to be where I am in a public place, I have a legal right to be there, and someone threatens to, or I perceive reasonably that I am in fear of imminent death or serious bodily injury by someone else, I no longer have a duty to retreat. I don't have to run and hide if I am legally allowed to be where I am and I'm not the aggressor. So there are some nuances there. What that allows is for my defense counsel, if I were to use deadly force on someone, it allows for them, if I am charged, to file a motion to go in front of a judge, not a jury. It's not a trial. It's a pre-trial hearing that essentially argues that I'm immune from prosecution because I had a legal right to be where I was. I met the statutory requirement that they were threatening imminent danger, serious bodily injury, or death to me. And so I responded proportionately. It was a reasonable fear. And if that's the case, and I as the defense have presented just what's called a prima facie case, just enough evidence, the burden then shifts to the state, to the prosecutors in that hearing to prove by clear and convincing evidence that it was not lawful. And that's a significant difference because it's not just me proving it was reasonable. The law is saying we're going to presume it was. And so now the prosecutors have that extra burden not to prove quite beyond a reasonable doubt, but just barely under that it wasn't reasonable. So it's almost like a mini trial before the trial ever takes place, where the prosecution is kind of having to lay their cards on the table to show a judge, no, we really should be allowed to send this to a jury. This action should not be, quote, a license to kill. There are too many questions about the reasonableness of this, Your Honor. Therefore, we want you to remove this immunity or barring from prosecution. So that's the significance between the two. If I, as a defense counsel, file a motion to dismiss and the judge denies that and says we're not going to let the stand your ground defense immune them or bar them from prosecution, then when we go to trial, I'm still allowed to use the self-defense to try to convince the jury that my actions were reasonable and to try to get an acquittal that way.
So if someone were to say, I was in my home, so I had a right to shoot, what statement is missing from that to make it legal?
Some big ones. One is I was in reasonable fear that someone was about to kill me or create serious bodily injury. The statute even allows for like a forcible felony. There's several felonies that fall under that. So number one, that reasonableness of the fear that was imminent, not I thought they might go get something and come back and hurt me. I thought in that moment, it was I had to defend myself or I was going to die. That is the real significant portion that's left out of that statement. But then in addition, even if I were to say that, law enforcement is still tasked with determining, is there evidence to support that? Or is that me just having done a good job of knowing what the law was and saying the magic words to keep law enforcement from arresting me?
Now, let's focus on the most important physical fact of the case, that door. According to the state attorney's office, Lorincz was accused of shooting AJ Owens through a door. The door matters because self-defense is about necessity. If someone is inside, another person's outside, and a locked door separates them, the legal question becomes what made deadly force necessary at that exact second? That's the question the jurors had to wrestle with. It's not enough to say there had been problems before. It's not enough to say there had been yelling. It's not enough to say someone was upset at the door. The law asks whether the person using deadly force reasonably believed deadly force was necessary to prevent imminent death, great bodily harm, or a forcible felony. And when the door is closed, the defense has a problem because the jury can ask, was AJ Owens inside the home? Was she armed? Was she unlawfully and forcefully entering? Was deadly force the only reasonable response? Had law enforcement already been called? Could Lorincz have waited? Could she have moved farther away from the door? Was the door itself a barrier? And here is the hard truth. A closed door does not automatically defeat self-defense. There could be cases where someone is breaking through a door, entering by force, or creating an imminent threat from the other side. But in this case, the jury rejected the idea that Lawrence's fear justified firing through that door. This is why the case is so important for understanding Florida law. Stand your ground is not a shield for every person who claims fear. It's a protection for lawful defensive force. And the jury decided this shooting was not lawful defensive force.
So in this particular case that we're examining, how does that closed or locked door affect that Florida self-defense analysis that we're talking about here?
In several ways. In this particular case, and again, I wasn't part of this case, so I, like our viewers, probably only know what has been media portrayed or in the documentary, which was fantastic because it was done through the body cam of law enforcement, which is such a great way to feel like we're getting the real story as opposed to an agenda either way from a documentary. But in this particular case, a closed, locked door for the defendant should have been a barrier of protection in their mind. There was nothing that I heard or saw to suggest that the victim in this case was trying to gain entry. So that locked door is the threshold according to the law. And if the victim that was on the outside of the locked door had an axe and was trying to get through the threshold, well, that's a different situation. Had there been evidence that they were trying to pick the lock or that they were trying to shoot the doorknob to gain entry, that would have been a different situation. But the facts as I understood them to be was that the door was locked. The victim on the other side was agitated, was emotional. So I have no doubt that they sounded irate. As a mom, I would too. But that locked door, per the law, without any evidence of the victim trying to get through it, was a place of safety and security, which would not or should not have allowed the defendant in this case to argue that they were in reasonable fear, objective or subjective, of imminent danger to themselves. Additionally, they were armed. They had many areas to go hide, to seek cover if they were afraid, not again that the victim was trying to come in. They also were on the phone with law enforcement. My understanding was being told, we're on our way. We're just a minute or two out. So they had every reason to believe that help was on the way. And to my knowledge, the facts did not escalate to where the victim appeared to be intruding into the house in any way, shape, or form.
Yes, yes. So as a prosecutor, what would you want the jury to focus on when the shot was fired through the door?
As a prosecutor, you're always asking the jury to see the big picture, to see the totality of the circumstances. So, yes, there's a locked door. Again, the victim had no evidence of escalating to the point of intruding. So, this is what in the law it would be like a blind shot. The person is shooting into a locked door that they can't see out of. Are there 4 children that they're shooting at? Is there a pizza delivery man standing out there? Some doors are completely glass. So you can see, or at least see the silhouette of someone on the outside. From the documentary, that did not appear to be the case. So essentially, the defendant could not allege, I saw them taking action to intrude. I saw them starting to use a screwdriver to get in. They couldn't say all of the neighborhood children weren't standing out. So as a prosecutor, I would be asking the jury to focus on that door was a protection to the defendant in this case. And to blindly shoot them through it is not reasonable. It certainly should not be legally justified. I would also have encouraged them that door provided the barrier, but the person that she heard on the other side, the mother, the victim in this case, she had a 3-year history with. There had been some verbal altercations, but I did not or don't recall seeing anything where there had been any physical aggression on behalf of the victim. So we're not even talking about a situation where a defendant could say, this person has beaten me up or has battered me so many times or has pointed a gun towards me. So this defendant had 3 years of history where the victim had not been physically aggressive. So a locked door should have certainly reasonably let the defendant think, okay, well, she's never been physically aggressive before, and I'm behind a locked door. So yes, I have a gun in the event that she were to get in here. I have every reason to be in my house. I'm calling law enforcement. I'm doing all those things. But that locked door, as a prosecutor, I would be suggesting to the jury, as I imagine they did in this particular case, that was her safety and protection from what she claimed was a threat on the outside. And so that locked door in this particular case, I believe, looking at the totality of circumstances, would have been significant for prosecutors to point out to the jury over and over again as a reason to reject a self-defense claim in this case.
Now, let's talk about one of the most controversial parts of the case. Why was Susan Lorincz charged with manslaughter instead of second-degree murder? The state attorney's office addressed this directly. In its charging announcement, the office said it carefully examined both second-degree murder and manslaughter with a firearm. The office explained that second-degree murder would have required proof of a depraved mind toward the victim at the time of the killing. The state attorney said that requires evidence of hatred, spite, ill will, or even evil intent toward the victim at the time of the killing. The state attorney's office also said that as deplorable as the defendant's actions were, there was insufficient evidence to prove that specific required element of second-degree murder. That's important. Prosecutors don't get to charge based only on public outrage. They do not get to say this case is horrifying, so let's charge the highest thing we can think of. That may feel emotionally satisfying, but legally that can backfire. The state has to prove every element beyond a reasonable doubt. So if they overcharge and cannot prove one of those elements, the whole case can be put at risk. And nobody wants a case this serious lost because the charge was emotionally appealing but fragile. Manslaughter with a firearm allowed prosecutors to argue that Lorincz intentionally committed an act that caused A.J. Owens' death without having to prove the higher mental state required for second-degree murder. That distinction frustrates people. I get it. A woman died, children lost their mothers, neighbors lived through repeating conflicts. And that word manslaughter can sound too small for the damage done. But in court, the question is not whether the harm was enormous, because it was. The question is, what charge can the evidence prove? That's not always satisfying, but that's how criminal law works.
So why might the prosecutor charge manslaughter instead of second-degree murder in a case where the facts were deeply disturbing, there was racial tensions, it was an ongoing dispute, the public was up in arms?
So all of the reasons that you have just outlined is what I would suggest as a former law enforcement officer, former prosecutor. All of the reasons that made this such a high profile, such a emotionally charged, understandably, such a controversial call. From my experience in working in law enforcement and the prosecutor's office, those are the cases you can be certain a state attorney is groveling over every detail to make a wise choice, not taking them lightly, realizing how much is at stake, how much the public is putting scrutiny on the decision. From a prosecutor's perspective, the burden of proof of beyond a reasonable doubt is the highest in our American legal system. It is not 100% certain, because we could never convince somebody unless they were there to physically view something of 100% certainty. But if you were trying to equate a number with it, it's basically asking a prosecutor to prove to this jury about 98% certain that this happened and this is the person that's responsible for it. That is an extremely high burden, and it's set that way because of the freedoms and the liberties that we're taking away from criminal defendants if they're found guilty. A state attorney, a prosecutor has to prove every single element of whatever charge they make. In this particular case, the state attorney chose to go with the manslaughter charge. I know there was a lot of public outcry because the term murder in and of itself sounds so much more sinister because it's designed to be. It shows a mental intent, a guilty mind, an actus reus that shows this person did it on purpose, they were meaning to do it, and they were malicious in doing it. Sometimes first-degree murder obviously requires premeditation. They thought about it, they wanted to do it. That murder charge that the state attorney's office could have charged in this particular case was a first-degree felony. Instead, they went with a manslaughter charge, which was also a first-degree felony, meaning the penalty was going to be the same, up to 30 years for either of them. But the elements on a manslaughter charge were much, I don't want to say a sure thing, because when you're talking about a jury, you're never talking about a sure thing. There's always the possibility that they will do something very unexpected. But the elements in the manslaughter charge were significantly different because it did not require the existence of what's called a depraved mind. The murder charge would have required that the state prove to the jury, to every juror member, beyond a reasonable doubt, that the defendant had an existence of a depraved mind at the time of the killing. There was arguably evidence that they may have been able to show, but the likelihood of being able to prove that to every juror to secure a conviction is a huge risk. Instead, the manslaughter charge that they actually went with, the manslaughter with a firearm, again, as a first-degree felony, getting the same penalty with conviction, did not require that depraved mind. All that the state was required to prove essentially was that aiming a firearm at a door and making the blind shot, knowing somebody's over there, was enough to prove manslaughter with a firearm. So not to in any way suggest that the state attorney's office was taking the easy way out, but the risk that they would have had by charging the what seems to the general public as the more sinister murder charge, although they would have gained no extra time in the sentencing, they would have risked an acquittal. They would have risked a hung jury because they may not have been able to convince every juror beyond a reasonable doubt that the depraved mind that's required by the murder charge was there. And so that is why I believe that the state attorney in this case, after weighing, I'm sure after having many sleepless weeks of determining what is justice for the victim and the victim's family in this case, was such a tragic outcome, especially for the 4 children. I suspect that that is why they went with a manslaughter charge over a murder charge. And I would have done the same thing had I been in a position to make that call.
So the risk of overcharging a case is that they could be found not guilty, or like you said, a hung jury, and then they walk. Whereas
Absolutely.
they can prove beyond a reasonable doubt the elements of manslaughter, they're more likely to get that conviction.
I think a prime example is the Casey Anthony case. I think that's an example where most of the watching world thought she had something to do with the death of Kaylee. But she got a not guilty because the charge that was levied by the state attorney was something that when you can't prove, even if it's by deterioration over time, but by evidence forensically, when you can't prove the cause of death, it's very challenging to prove a murder. But had they charged neglect, there were a variety of other charges that they could have done less than murder, where they probably could have had a conviction because they would have been able, beyond a reasonable doubt, to prove every element. So yes, the risk of overcharging is detrimental in that you may never get justice for the family because a jury may acquit, not because they think the person didn't have something wrong, but they just didn't think there was proof beyond a reasonable doubt for every element as the law requires them to have for the guilty conviction. Or a hung jury, which would have, as you said, in the moment, it would have allowed the person to have to be retried if the state wanted to. So we're looking at taxpayers' resources. We're looking at time. We're looking at keeping a family in that bubble where they can't have closure because it's still in limbo. They're still having to go back through the trial process at a later date and time with no assurance then that they're going to get a guilty conviction as well. So the danger in overcharging really does a disservice to justice. It does a disservice to the taxpayers, but ultimately it does a disservice to the victim and the victim's family.
Susan Lorincz went to trial in August of 2024. The Associated Press reported that she was charged with manslaughter and faced up to 30 years in prison. During the trial, the central question was not whether A.J. Owens died. She did. It was not whether Lorincz fired the shot. She did. The question was whether that shooting was legally justified. The defense had to lean into fear. The prosecution had to lean into reasonableness. Lorincz could say she was afraid, but the jury had to decide whether that fear was reasonable and whether deadly force was necessary. That means the trial was not just about emotion. It was about evidence, the door, the timeline, that prior conflict, the 911 call, the physical scene, witness testimony, the legal instructions, and the credibility of the self-defense claim. This is what makes criminal trials different from public debate. Public debate asks, whose side are you on? A criminal trial asks, what can be proven under law? That's a much narrower question and sometimes a much harder one. The jury ultimately convicted Lorincz of manslaughter. The verdict tells us something very important. They rejected that self-defense claim. They did not have to decide whether Lorincz had ever felt fear during the neighborhood conflict. They had to decide whether the shot through the door at this moment was legally justified, and they said no.
So when that defendant claims self-defense at trial, what is the jury actually being asked to decide?
They're essentially being asked to decide whether a reasonable person in the defendant's shoes in that moment would have believed they were in imminent danger and whether the force they used was reasonable or proportionate to what was happening. So a jury is being asked essentially to step into the shoes of the person that's saying, I was in fear for my life, and determine, was that reasonable? And if it was reasonable, did I do only what I should have done, or was it overkill? And if it was, then it's not reasonable. So that's essentially what a jury's being asked in a self-defense type case.
And that she was facing imminent danger,
Absolutely.
bodily harm, death.
Absolutely.
Yeah.
Not just she was going to yell at me because I threw something at her kid. And that's in this particular case, at least what the evidence suggests, is the mom was coming over to say, what do you think you're doing? Don't throw roller skates at my kid. Leave them alone. That might not be pleasant to hear, but that is not legally grounds to pull out a gun and end someone's life.
Through a door.
Exactly.
Even they were face to face, and this woman's much bigger than I am, and therefore we're in an argument and she's coming at me, and I felt in fear because she's bigger than I am and she's younger than I am. And no, there was that locked door in between them.
That's not what the law is supposed to be a shield for. And in this case, fortunately, in the way that the prosecution or the state attorney's office in Marion County chose to charge it, despite it not sitting well with the public, this defendant did not get to make the stand your ground law look like it was to shield people from criminal activity, fortunately, because there's a lot of critics of this law because it's very controversial. Not every state has it. Florida was one of the first back in 2005, and we've seen lots of changes or additions to it. And so I believe this is a poster case for how someone asserted it, but the jury and the law said, absolutely not. This is not what stand your ground law is meant to do. And you're not going to get away with it by using the magic words in this particular case.
How should our viewers think about the difference between being afraid and having a legally reasonable fear?
5-year-olds are afraid of bears in their closet or a lion under their bed. That's a fear. It's not a legally recognizable, reasonable fear under the law. Completely different. So for self-defense, being afraid is subjective. It's this particular person. It's an emotional response. It's subjective to me, because what makes me afraid doesn't necessarily make the next person afraid, and vice versa. But a reasonable fear in the eyes of the stand your ground self-defense law is an objective legal standard. It's saying what a reasonable person, hypothetical reasonable person in this exact same situation also believe they were in imminent danger of death or great bodily harm. So it's separating out, what did this particular person feel because of who they are, and maybe they're anxious by nature. Maybe they had somebody at their house 5 years ago try to break in and steal something. So they've got a subjective predisposition to it, but the law is saying we can't do that. We have to say this fictitious, reasonable person, would they believe that death or serious bodily injury was imminent? Law rarely allows self-defense to be based on personal feelings for good reason, because it could be an irrational assumption. A reasonable person might not fear that way. But the legal standard, the objective fear, reasonable fear, is based on evidence outside of what's going on in my mind. It's an assessment of a threat. It's what a normal, intelligent, rational person believed they were in that same danger standing in your shoes. I had 2 examples. So if a stranger walked up to someone on a sidewalk and loudly shouted at them, "What time is it?" Maybe they were hard of hearing. But because the person that was hearing that had a personal bias or maybe suffered from an anxiety disorder, they started to feel panic and terrified. They thought, oh my goodness, I bet they're about to attack me because they're yelling. So they pull out a gun and shoot them. That is not an example of a reasonable standard, an objective legal standard that a self-defense is going to be permitted to be used.
It doesn't mean that their defense can't argue based on their
Exactly.
history and whatever. Obviously, the defense can still come back and argue, well, this person had, years of anxiety, or this person was held in captivity. And so any loud noises startle. I mean, that would be the defense's job to argue that, but it's not
Absolutely.
saying legally as a whole for the community.
And what that is doing, it's not permitting the pretrial immunity motion to dismiss that comes with stand your ground. It is saying we're going to let a jury decide this. And just like you said, we're going to give your defense counsel an opportunity to argue to the lay persons of this jury that ultimately get to decide the facts of this case, whether that was reasonable or not. But we're not, as a matter of law, going to say the state can't charge you, because that is a slippery slope. We would have no guidance because there would be no consistent line as to, well, if I just say that I suffer from PTSD, can I do whatever I want? No, that's not what the law is designed to do. Now, as you stated, there very well may be circumstances in a person's past that a reasonable jury would feel like made it reasonable in that circumstances for them to defend themselves. So they still get their day in trial. It's just that they do not get immunity from being prosecuted because that was a subjective response, an emotional response, not an objective legal one. A different, just to contrast it, a reasonable fare legally, stranger runs at someone in a dark parking lot at night. The stranger has a knife and yells, they're going to kill you if you don't give them their wallet. Objective reasonableness. You're being told you see a weapon that's capable of killing you. This person is not somebody that you knew, is showing hostile, close proximity. That is an example where a reasonable person very well fears imminent bodily injury or death. And so that one would have a different situation. Difference between subjective fear, objective, reasonable standard of imminent danger. And I think that is kind of the significance between the way that the self-defense and the stand your ground. One is going to permit defense from trying to get you not tried at all. A judge makes that determination. A jury makes the determination as to whether it was a reasonable fear, because they're the trier of fact as our jury system is set up.
On November 25th in 2024, Susan Lorincz was sentenced to 25 years in prison. And this is where the case closes legally, but not emotionally, because no sentence gives Ajike Owens back her children. No verdict erases what the neighbor saw. No legal explanation makes the shooting feel less senseless. But the sentence does mark the court's final answer to that self-defense claim, that shooting was not justified. The use of deadly force was not lawful. And Florida's stand your ground law did not provide immunity. This case teaches us several important criminal justice lessons. First, stand your ground is not a license to shoot. It removes the duty to retreat in certain situations, but the force still has to be legally justified. Second, fear alone is not enough. The law asks whether the fear was reasonable and whether deadly force was necessary. Third, a locked door can matter. Fourth, charging decisions are not the same as public opinion. The state attorney's office explained that it considered second-degree murder, but chose manslaughter because of the legal elements it believed it could prove. And fifth, the criminal justice system can produce a legal outcome while still leaving a community wounded. That's the part we can't ignore. Ajike Owens' death was senseless. Her children lost their mother. Her neighbors lost their sense of safety. And this case became a national conversation because it sits at the intersection of race, fear, gun laws, neighborhood conflict, and the limits of self-defense. If you watched The Perfect Neighbor on Netflix, you saw the human tragedy unfold through footage that is hard to forget. But when we study this case through the criminal justice lens, we see something else too. We see how law enforcement had to evaluate probable cause, how prosecutors had to choose charges based on elements, not outrage, how the defense tried to frame the shooting as fear, how the prosecution framed it as deadly force, and how the jury ultimately decided that Florida law did not protect Susan Lorinc's decision to fire through that door. I'm Chris, and this has been Eagle Eye on Crime. Stay curious, stay informed, and always look past the headlines. I'll see you in the next video.